Good day. Today we're going to be dealing with chapter 2 of our notes, the sources of law in Zimbabwe, and I will not stress this enough. The notes are only a guideline on how you are going to be reading the textbooks that have been referred to you. So let us begin. Our presentation today we're going to be dealing with primary sources of law, the constitution, legislation, common law, custom, authoritative text, as well as case law. So, what are the sources of law? These are the places where the law originates. This is where we find the law, right? When a person has a case or a dispute, where do we get the authority to support our arguments? So this is what we're going to be talking about. Now, what are primary and secondary sources of law? Primary and secondary sources of law, these are the types of sources that we have. For primary sources, we are looking at sources that have binding authority. This is the authority that is binding on everyone. Everyone is required to adhere to these sources, like the legislation and the constitution and so forth. As opposed to secondary sources, these are persuasive authority. They just persuade you into interpreting the law in a certain way. Examples are modern writers, people like Maduku in Zimbabwe and so forth. Now, note that at the outset that Zimbabwean law is not codified, meaning that we do not have primary sources where we don't have a primary source where all laws can be found. And I gave an example in class, which is opposed to the Justinian era in terms of in the Roman law, wherein they could look at one place to find all laws that were applicable. So this is different. In Zimbabwe, we do not have one codified source of law. The only exception is that we have the criminal law with the legislation, the Criminal Law Codification and Reform Act. It codified criminal law, but that is the only exception. Let's continue. Now, the sources of law in Zimbabwe are as follows. We have the constitution, the legislation, common law, which entails judicial precedent and Roman Dutch law. We have customs, modern works of writers, as well as case law or law reports. Now, the Constitution of Zimbabwe. The Constitution of Zimbabwe. The Constitution of Zimbabwe, the Act number 20 of 2013, this is the recent amendment. The Constitution of Zimbabwe is the supreme law of the country, and Section 2, subsection 1 says that the Constitution is the supreme law of Zimbabwe, and any other law, practice, custom, conduct inconsistent with it is invalid. This is the same old song that is there in most constitutions all around the world. Even the South African Constitution has the same section. It says that any law or legislation or anything that is in contrary to the Constitution will be invalidated. Now, this shows a direct influence of the Constitution on legislation, right? And also it regulates the organization and structure of the state. That's where we find state organs given mandate or authority. Organs like the legislature, the executive, they're mandated in terms of the Constitution. Now, it provides a general norm standard which has a direct or indirect influence on the sources of law. Like indirect influence, we're talking about the fact that any legislation should be read in line with the values that are entrenched in our Constitution. I given an example in class, and we're just saying that any interpretation that is to be made, it should be made in line or in the same respect as the values that are entrenched in the Constitution. Now, we are now off to legislation. Now, what is legislation? This is a law that is laid down by an organ of state, and in terms of Zimbabwean law, the organ being the parliament, mandated by the Constitution in terms of section 116, gives the parliament as well as the president the power to enact laws that govern human conduct in Zimbabwe. Now, in terms of legislation as well, we have the primary and secondary legislation. Right? Primary legislation being the legislation that is created or enacted by the parliament as well as the president, right? The normal legislation that we are all aware of. Now, in terms of secondary legislation, this is legislation that is written and enacted, not really enacted, written by the ministers or other departments stemming from a mandate or the delegation by the parliament to do so. Now, in such a case, it says that the parliament has effectively delegated its lawmaking powers to a minister or an official in a government department who formulates secondary legislation, which is known as delegated or subordinate legislation. So these pieces of legislation are called statutory instruments. This subordinate legislation, these bylaws, are the affairs include bylaws that are given in municipalities to write and so forth. Now, a statutory instrument must be consistent with the relevant primary legislation that has given it the authority, right? Not only that, but it must also be in line with the Constitution. Failure to do so would be ultra-virus on the part of the statutory instrument or on the part of the secondary legislation. Now, when we're talking about ultra-virus, we are saying that it is outside of the powers that it has been given. And I gave an example in class, and I said, if I were to remove my jacket being the authority of being a lecturer, and give it to someone else, a student in class, to do a presentation on whatever that topic that I've given them, I've given them the mandate or authority to act briefly as a lecturer and present that topic. If now that student decides that they are going to start marking people's papers and so forth or writing tests, then they are acting outside of the authority that I've given them, right? But if they only act according to the authority that I have given them, they're acting within their powers, which is intra-virus. Now, let's continue. So, the doctrine of legality, it says that in making secondary legislation, there has to be it has to be in line with the authority that has been given, right? So, like I noted there, it must be within the powers of the delegated authority. It must not be grossly unreasonable, and it must comply with the Constitution. Now, as we continue on, a statutory instrument must pass both constitutionality tests. We talked about this. And then there is legislation in Zimbabwe, cited in two ways. So, legislation, when you are referring to legislation, be it in legal documents or when you are writing an assignment, when you are referring to them, you refer them in either two ways. The ways by reference to the chapter is noted, and also by reference to the short title, the calendar year, and its number as noted on the slide. Now, statutory instruments are cited in only one way. They have no chapter number. Reference is made to the title, the calendar year, and its number in the year in which it was gazetted. This number refers to the order of gazetting, right? You asked this in class at one time. Well, what does the number mean? So this is what it means. It says the number means the order in which it was gazetted. Now, I gave an example there. We have the presidential powers, temporary measures, the labor relations regulations, 1998, statutory instrument 368A of 1998. Now, as we continue on, an act of parliament does not fall into disuse. It does not come to an end without any valid reason, or it does not expire. You cannot just wake up and say, this statutory instrument has been there for 200 years. Because it has been there for too long, it must have expired. There's no such thing in terms of law. It can only come to an end in three ways. One, when it is repealed, right? When it is invalidated, or when it is found to be void and be inconsistent with the Constitution. And the third one, through the influx of time in situations where an act is meant to be limited. Now, there are some acts that are written that would refer to the fact that after a certain period of time, these things should be done. Like I said, legislation regulates human conduct. So they're saying that there are some legislations which are enacted for only a certain period of time, and when that time lapses, then it is no longer it comes to an end. It is no longer valid. Now let's continue. So the table shows how to describe statutes. When you are referring to them, you say that, okay, when there is a provision of a statute that you want to refer to, you say in section 1, subsection 1, paragraph A, subparagraph A of this provision, it says that this and this and this, right? When you are referring to a bill, you say clause 1, subsection 1, paragraph A, subparagraph A, it says this and this and this. So it refers to how you refer to statutes and so forth. The table shows all the different instruments that are there. We have schedules, we have statutory instruments, we have conventions and treaties. Now, the common law. What is the common law? In terms of Zimbabwean law, unlike English law where the common law are just judgment-made laws, in terms of Zimbabwean laws, and also in South Africa, the common law is made up of two components of non-statutory laws. Namely, we have a collection of rules and principles made by judges in previous cases, right? And then we have rules, principles contained in terms of the portion of body of law called Roman Dutch law. That was there at the time during the 1810. So this is what constitutes common law in Zimbabwe. Let us continue. We talked about what English law refers to as common law, but in terms of our law, common law entails the principles of laws contained in foreign time at the time of the imposition, and law derived from judicial precedent, right? So in terms of common law, we are looking at the law that was being used in the time of 1810 in the Cape of Good Hope, which was the Roman Dutch law with English influences. So this is the common law in Zimbabwe. It tells of Roman Dutch laws, judicial decisions, judicial precedent, actually. So this is the common law in Zimbabwe. And there are some notes that are owed to you. I'm going to provide notes on the different Roman Dutch jurists that were there, Hugo de Groot, Johannes Vert, and the others. Now let us continue. Now, what do you mean by judicial decisions? Judicial precedent, to be more exact. Now, it is not everything in a previous case that is binding on a future court. For a preposition to be binding, it must have the following requirements. So, on this slide, we're going to discuss the fact that the judicial precedent that we refer to as the common law in Zimbabwe, we're saying that the previous decisions of a higher court are binding or influential to future courts of a lower court, and those binding decisions would affect the decisions of those lower courts, future lower courts. Now, for those decisions of those higher courts to be binding, it should be a proposition of law and not a proposition of fact. The proposition must be of a ratio dissident, which is the reason for judgment, right? We discussed in class in Richikweche, we said the reason for the judgment in Richikweche, when they were talking about the fact that your physical appearance does not matter when we are determining the fit and proper requirement of being a legal practitioner in Zimbabwe. So that was the reason for the decision. So that reason that was given in Chikweche case is binding on all the other lower courts, so the High Court and the Magistrate Courts, and in their decisions with regards to that same legal principle. So that's what they will be talking about in terms of judicial precedent. Now, the ratio dissident is the principle of law upon which the decision is based, right? However, in a judgment, it is common for a judge to make statements of law in passing, and these are called the obiter dictum, right? Any comments that are made in passing to support the reason for the decisions are called obiter dictum. We talked about this in class. Now, as we continue on, there must be no material difference between previous case and the case in question. So when you're applying judicial precedent, there must be no material difference material difference between the cases that are being dealt with in the future lower courts, and that was also in the case that was being dealt with in the judicial precedent that we talked about. So the facts have to be the same, the material facts have to be the same, and then the decision would be binding because the circumstances are the same. Now, the hierarchy of courts, we talked about this one. It should be binding on the courts deciding on the case in question, considering being given to the hierarchy of courts. So if a judicial precedent is made in the Supreme Court of Zimbabwe or in the Constitutional Court of Zimbabwe, then it is binding on the rest of the other courts, the High Court, the Magistrate Court, the Small Claims Court, going forth. And it is important to note that foreign courts' decisions are not binding, but they're merely persuasive. If you have a foreign court that decided in a certain way over the same circumstances or situation, then it is merely persuasive to lower the court in your favor, but it is not binding on the court to decide the same. Now, as we continue on, there are advantages and disadvantages of judicial precedent. Advantages being certainty, predictability. You want to get into court knowing that the law is going to be interpreted in a uniform way. But the disadvantage now is the lack of adequate flexibility to change the law to meet changing times and situations and so forth. Now, customary law. What is customary law or custom, right? So in terms of custom, we talked custom refers to rules that become binding in the course of time through observance by the community in question. Now, these customs are not necessarily written down, right? So if a certain community or certain country is bound by certain rules that are unwritten and have been observed over a period of time, they become their custom, and the custom is binding. Now, in terms of Zimbabwean law, we have two customs, or two types of customs, that are binding to us. There is the general custom, and then we have African customary law. The general custom being the custom that we are going to talk about right now. General custom is a custom that is legally binding if it satisfies four requirements. One, it has to be reasonable. It has to be long binding, meaning that it is clearly established for a long period of time, and it should be uniform and certain. Now, we talked about the Van Bredak and versus Jacobs case. The citation is in your notes, the full citation. Now, in this case, the court upheld a custom in the fishing trade whereby persons involved in fishing could lay a claim to fish in the sea not yet captured by their nets, as long as they were in the line of their nets. Now, in terms of this case, there were two parties that were arguing that the fish, another party was saying fish in the sea are open season for everyone as long as they're still in the waters, but the other party was saying that no, even if they were in the water, as long as they're within the line of our fishing nets, it is mine. I have claim over it. Now, the court decided that it was a general custom that was done for a long period of time, and it was reasonable, and it was binding, and met all the requirements to be a custom, and it upheld that custom and held it to be valid and binding on all parties. Now, as we continue on with general custom, the onus is on the person who relies on the existence of the custom to prove each of the four requirements that we talked about on the previous slide. But the problem now is regarding the proof is trying to prove some of the elements. It is hard for to prove a custom is reasonable or is long binding. So the adducing of evidence would be very complicated for the person that is alleging. Now, according to Wood, custom is not reasonable if it is contrary to public morals, contra bonus mores. If it is contrary to public morals, so that is not to consider. Now, as we continue on, custom is not only on general custom that we talked about, but in terms of Zimbabwean law, we have African customary law. It is duly authorized and it is binding. It stems even constitutionally recognized in terms of our law. The sections are there in your notes. And then we have the Customary Law and Local Codes Act that also recognizes as such. So in terms of Zimbabwean law, we have a dual legal system comprises of two, the general law as well as African law. Now, this means that in certain matters, there is a potential application of two different systems of law with the different legal consequences, and it is now customary law applies under two circumstances where the provision of the relevant act say so, and in terms of the choice of law under section 3 of the act. Now we're going to be talking about that one. So in terms of the choice of law under section 3, customary law applies in three circumstances. Firstly, where in terms of civil matters, this is the case we referred to in class, and where the plaintiffs or the parties agree that it should apply, then they can apply customary law. And then where there is no agreement, the court may impose the application of customary law on the basis that it is just and proper, right? So where it is just and proper, the relevant case is the Lopez versus Ngumalo case. We talked about that one. Now, in terms of the choice of law formula under section 3, It applies unless justice of the case otherwise requires. Now there are numerous cases that refer to this last element. You should refer to your notes and the case laws that are referred to them. Authoritative texts. Now, as we talked about them when we're talking about secondary sources of law, these are the persuasive texts that help the court or persuade the court to interpret the law in a certain way. Authoritative texts include texts from Roman Dutch jurists, texts from contemporary authors like Maduka, authors that we talked about, Michael Kidd in terms of environmental law, Van der Voort in terms of the law of delict, and so forth. Now, authoritative text refers to writings by leading authors. We talked about this, the fact that they are persuasive in nature, and the authors among which are judges, scholarly level piece of writings, and so forth. Now, law reports or case law. So, an essential component in terms of our law are law reports. Judgments from the superior courts are required by law to be in writing. Judgments from the High Court and the Supreme Court are written down, and they would be written as reported or non-reported laws, but all of which are used as authority to further an argument in court. A full law report usually includes the following details: the names of the parties, the court in which the case was decided, dates, and so forth, indication of whether the judgment was reserved, and so forth. So this is what law reports are all about. A judgment is not selected for publication, it is unreported, but both of which, reported or unreported, they are equally binding to a court. Now, these are the sources of law in Zimbabwe, a general summation of it. We talked about the constitution, case law, custom being general or African customary law. We talked about legislation, case laws, and so forth. Thank you. We're going to see you in our next class.